Right, people, I think we can start. There are a few people in the waiting room still, but as they come in, John will allow them in. Welcome to the part 2 of the rentals. Everything about rentals. I'm going to share my screen with you quickly, and then we can start. Last week, our speaker is Heinrich Schmidt. I've known Heinrich since the early 90s. We did our articles here in Benoni at the same time, early 90s. Heinrich joined Bennett McNaughton attorneys in 95 and became a partner in the firm in 1998. Heinrich is a admitted conveyancer, and he's got his own rental book. Heinrich says he's got about 250 rentals, and he's completed around about 500 evictions and commercial evictions successfully. So there's no doubt Heinrich is the man to share his knowledge with us. Heinrich, thank you so much. We appreciate it. And over to you.
Thank you, Jan. Welcome to everyone joining today. Thank you that you're giving up your time. I hope that you find this a productive session. I hope that you will be entertained, but I also hope you will be educated. The opportunity to do this two-part series with Jan took me back to my early days in the articles, and some of the mistakes I made. There are few things as clever as a graduated law graduate who's starting articles. I guess the only thing that's brighter than that, or who has more answers, is a newly admitted attorney. And it's in this context that I encountered some of my first matters, rental matters. I guess my first recollection is doing rental matters against the so-called runners. We would call them runners. That's when you realize that your tenant is about to make a skip at the end of the month, or over the weekend, or over the long weekend, and the rent's not paid, and they're going to run and leave you high and dry with only a deposit if you're lucky. I had some fun matters back then. We would have a call where the landlord would have a good relationship with his neighbor, and the neighbor would be the spy, and the neighbor would call us directly and say, listen, man, there are boxes being delivered next door. These guys are about to run. You also had the opposite when people would say there are more people moving in. And we had to make plans in each one of those cases. During my career, I've had rental matters against casinos, catering companies. I've had a murderer, literally pending trial. I've had grannies, I've had bouncers, I've had locals, I've had foreigners. And you have to kind of make sense of these things. And when you're young and arrogant, you learn your lessons, sometimes at the expense of your client, but mostly at the expense of your pocket, because you take matters on the understanding that you are able to do certain things, and sometimes it takes longer, and you've provided a costing to your client, or your arrogance overtakes you, and you say to yourself, I can get this done in X amount of time, not knowing how the future works, not knowing how the matter would work out. The amount of rent that is payable is really only an exercise in economics. The principles that apply and the stuff we'll discuss today are the same, whether the rent is R1 million a month, which I have dealt with, or whether it is 2,000 Rand a month. Principles remain exactly the same. Can we go to the next slide, please?
Heinrich, sorry, I've forgot to say that if there are any questions as Heinrich is going on, you'll see there's a chat box. Just type your question in, and then we will deal with it afterwards. All right. Thanks, Hein. There's your first slide.
Perfect. So examples of drama. In my local jurisdiction, which is Germiston, the first eviction I did in this area was in 2003. And I know that our guests listening in today know what drama can be. But when you get called 70 times on one morning, because of an eviction taking place, with people trying to make arrangements, people trying to stop the sheriff, all sorts of hustling going on, you know you've got trouble. And that's the type of stuff that you cannot prepare for. So we've come to understand that if an eviction is complete and the sheriff is busy removing the people from the property, you can write that morning off or that afternoon, and you can expect to be at the office. You can expect to have a lot of phone calls. We have one individual that we did an eviction for. I hinted at him or about him last week. This individual, we evicted him from a property. He hustled his way into another property 300 meters from that one. That owner came to see me about a year later because things went okay for a year. And he fell off the wagon, so to speak. I brought an eviction application against this gentleman again. I warned the sheriff that this is a slippery character. He had an enormous amount of small ornaments in his house. So the sheriff took 2 days to pack him up. And for those of you who don't know, when the sheriff does an eviction, they literally pack your stuff up and put it on the pavement, everything. And if it's ornaments, they have to toss the ornaments in boxes and pack it and put it on the pavement. So it took 2 days for this gent to be evicted. He tried all sorts of tricks to stay in the property. The next morning after he was evicted, I phoned the sheriff and I said, "Where are the keys? Because surely you changed the locks." Well, the sheriff said he didn't change the locks. He couldn't get hold of the locksmith. He had some sort of excuse. Well, lo and behold, our occupier had moved back into the property that very night, settled back in, and we had to do a spoliation application, which is something we'll touch on a bit later. Got him out again, and as I sit in my office now, I see out of the corner of my eye yet a further eviction for this gent, and fortunately for him this time, the owner got onto me early. We took the appropriate action and removed him. Literally one individual who moves around in one block in our area and has been scamming people for the better part of 10 years. So there are professional tenants, professionals that are waiting for a gullible landlord or gullible agent to place them. That's just one of the examples I can give today. Thanks, Jan. Last week, for those of you who joined us last week, we had a discussion regarding risk areas, things that you should look out for. In the current instance, the tenant is not taking my calls. If you battle with a sense of rejection, then a tenant not taking your calls is one thing. A tenant who is not paying and is not taking your calls is a definite warning sign. The other one that I flagged for the slide today is the tenant sent me a proof of payment. It's not really a proof of payment. The so-called fake proof of payments, you can produce them with a PDF editor in no time today. That is a clear signal that you've got problems. The clearest one is when you confront the tenant about lying, not paying, not taking calls, and the tenant says to you that he or she has squatter rights and that you need a court order to get them out. So either they went to the big law practice, Google Incorporated or Facebook Incorporated, where a lot of free legal advice seems to be floating around, or they've done their homework, or they are in fact experienced tenants, people who have been through them all. The other ones that I mentioned last week, I want to come back to the concept of the fluid tenant. A and B move in together, very much in love. They break up. A is the one who has the money, but he leaves. B gets a new boyfriend, Mr. C. They last literally a few weeks, and then B moves out. You don't have anyone on your lease in that property, and suddenly your rent's not paid. That is an absolute crisis waiting to happen. The other issue is also prepaid meters that fail, that are tampered with. If there is a direct connection with the municipality for utilities, disconnection notices arriving. Those are indications that things can go wrong, or that have gone wrong, or that things are so far gone, it's only you and the landlord who still have to make the discovery about how big the problem is. So those are the big things. Obviously, you are aware of people not paying the rent or the utilities, people wanting to dip into their deposits. When these things happen, there are good and bad responses. I'd love to tell you that you run to the attorney straight away. But before I do that and I promote our profession, and I do want to thank you for your loyal support, I want to point out a few things that you can do to be clever about things, and things you can do to be less wise about matters. Can you please turn the slide for me? Okay, so so these aren't things that I fabricated. These are actual and real scenarios that we encounter. I know that there are some of you are smiling. Some of you may even have successfully used some of these items and some of these strategies. Let me just quickly take you through them. For those of you who are new in the profession, or those of you who have walked the straight path, here are some of the things that some of my clients have tried before coming to me. They would remove the doors to the property or the windows. I've had an enterprising landlord remove a roof or section of a roof. They remove the security gates, either motor gate or otherwise, or lock the gate. The one that people seem to love is the one where they say, I'm going to get a bouncer or heavy. I know this guy. Even tow truckers are scared of him. You know, he's the roughest guy in town and he can guarantee results. So I would never know how many times that's worked, but I can tell you of examples, and I'll show you examples shortly of how that fails. Interfering with the security, remove the gate motor, block the person's access, or suddenly discovering maintenance that you need to do at the property to harass the tenant. My favorite, and it's just because I'm an attorney and I see a lot of writing every day, would be the landlords or agents who do their own formal letters. So, and we'll talk about the consequences a bit. There's nothing wrong with being proactive, as long as you understand what you are doing and how you are affecting the machinery of the lease. So the items above, so that would be everything excluding a formal letter. Those things fall in the so-called spoliation space. Now, spoliation was one of the toughest things for me to understand as a young attorney, because I'm made to understand that the law is the law, and you get good guys and you get bad guys, and it's not more complicated than that. So, for instance, we would hear about spoliation, and spoliation is a remedy that's available to anyone. It is something that you can go to court for, and it's available to anyone from the public. Even a common thief can use spoliation. the definition of spoliation is the wrongful deprivation of another person's possession. And the purpose of spoliation, which is the order, is to prevent self-help. So it also includes shutting out motor vehicles, reducing the electrical load. That was a popular one some time ago. Cutting water. I mentioned the issue of maintenance. You know, the thing is, if you look at a classical example of spoliation, as they teach us, in practice, is that you would lose your TV to a thief. The thief would be walking down the street with your TV, and 2 days later, you just so happen to be on the same street, and you see there's my TV with someone I don't know, probably a thief, and you decide that you're not going to wait for the police or anyone. You simply go all in and you repo your TV. So that is an example of a person who can use spoliation against you. That is a person who even for a little while, maybe 2, 3, 4, 5 days, had undisturbed possession of an item, and the unlawful taking the law into your own hands qualifies that thief for approaching the court for a spoliation order. The example of the bouncers, I had a matter where we had a particularly crafty individual who was in a property, and I found out, I was busy with a matter, and I have a rule. When I attend to the eviction or rental matter, then you hand the matter over to me. I don't need assistance in the sense of, I don't need the landlord or the agent to terrorize the tenant, because it causes the matter to become an emotional matter. It exposes parties to risk. And it's something we can maybe touch on a bit later in the questions. But he decided to get a very large ex-security guard to visit the occupier. And during this session, the occupier took a photo of this guy through the side windows of the front door, client trying to literally break down the door and claw his way inside. Now, that's horrible stuff. If you're the attorney and you have to defend the client, and that type of stuff ends up in court or in court papers, literally having a guy with his face up against the door and the window trying to break into a place. It reflects very poorly, and it will set your matter back very badly. The example of cutting electricity. I had an agent who was a relatively good sales agent, but a very poor rental agent some 10, 15 years ago, who had also decided to put the eviction on turbo by adding the electrical disconnection to the process I was busy with. So whilst the eviction was going on, unbeknownst to me, the agent had gone and gotten access to the complex's main board and had literally just switched off the electricity to the unit and proudly proclaimed that to me. Well, it was winter, it was July, and it was cold. So the occupier did what any cold person would do. They made a nice bonfire on the carpet in the lounge. So instead of only losing rent, the owner of the property now also had to contend with a massive claim for damage to the property, because it was smoke damage and all sorts of things. So for those reasons, I'd be very careful to embark on that type of path. So the story about doing your own letters, we're going to come back to spoliation in a second. I really don't encourage those items, and I'll share with you in mistake number 2 why. But the problem with doing your own formal letters is this. We spoke about a toolbox last week with your application being part of it, and your inspection. And the most important part is your lease. Your lease is the machine that runs this transaction, and that gives you rights and gives your landlord rights. So we have since 2011 had immense complications in terms of how we do breach notices, how we handle people who don't pay. And those things were further complicated by the CPA. When the CPA, or Consumer Protection Act, came in, we suddenly had not only the lease, not only the framework of the lease, but the framework of the Consumer Protection Act. We already had the Rental Housing Act, which it had its own spin on how the landlord-tenant relationship should work. And what we found is that the CPA suddenly said, for the most part, you have fixed-term lease agreements, and a fixed term starts on day 1 and it ends on day Z. And for the duration of that, you have a fixed term. So if you want to place a person in breach, your 20-day breach notice, or your breach notice, is a 20-day breach notice. Now, let's say your lease is not updated and it says 7 days, then the CPA overrides that. You have the further complication of having to make sure that you can prove it was delivered. A lot of people use the TPN portal to generate their letters, but they've got no proof that the notice was actually delivered. And if it was delivered, sometimes it's to an email address that was replaced. There's no formal way in which domicile is dealt with, which means that it gets redone. And the problem that you have is people would not do a breach notice. So they would simply say, I give you a notice for the end of the month. I'll give you the notice for the end of next month. So the tenant doesn't respond, or he pays a bit of money and they forget about that notice. The problem is, writing letters in general is a lot like surgery. Just because you are able to perform some of it yourself doesn't mean it's a good idea. You really have to understand, if you write a letter, what are the consequences? One of the consequences, people, that I can share with you, if you give someone notice and you just send them this notice and it is accepted that it is a cancellation, and we don't have to get into the technicalities of that, but the moment you do that cancellation notice, from the day that lease is cancelled, you've got 6 months to get an eviction application issued by the court and served on that person by the sheriff. If you don't do that, the onus to find alternative accommodation ends up in the hands of the landlord. That's the so-called squatter rights that people are so afraid of. And by not using your notices and your process the right way, you can find yourself and your landlord in significant difficulties. Can we get to the next slide? And I just want to ask if it's possible. With the view I have some video active and I think some audio. If I can just ask if there are people who are on video that they can just switch off their cameras. It's distracting a bit from the slideshow that I'm following. Thank you. Okay, can I have a quick chat to you about the Rental Housing Tribunal? So the Rental Housing Tribunal is a creature of statute. So the Rental Housing Tribunal is run by the various provincial governments. The provincial government is authorized in terms of the Rental Housing Act and its regulations to have a tribunal where complaints and tenant complaints and landlord and tenant disputes can be ventilated. Typically, let's say you did one of the naughty things on the previous slide. You could find the tenant going to the tribunal think there's a local chapter in Boksburg. It's the main one for Gauteng is in Joburg. There's one in Boksburg, and there's one in Pretoria as well that I'm aware of off the bat. And they have various offices jotted all over the country. There's a process. The tenant can make a complaint and say they were mistreated in a certain way. They can say the electricity was disconnected, and they can raise any issue that is a concern there. Once a complaint is made, the tribunal has to investigate it, and there's a 90-day moratorium on eviction. So if you did one of those naughty things and the tribunal is investigating, and in fact the investigation went to mediation without resolution, and it now becomes a formal hearing, the 90-day moratorium on eviction can be used as a defense in the papers against you, and has been used. There's a difference about in terms of legal opinion on whether the 90 days is whether you can actually physically carry out the eviction or whether the process can start. The safe space for me to have my clients is to say, do not have any issues with the Rental Housing Tribunal when the papers are issued. After the court papers are issued by the court and they are served on the respondent, the Rental Housing Tribunal cannot effect a moratorium on eviction any longer. You should also bear in mind, although very rare, there are criminal sanctions for certain things. The Rental Housing Tribunal can issue spoliation orders. So if you've locked someone out, they can do that. A spoliation or an order, let's just call it an order made by the Housing Tribunal, has the effect of a magistrate's court order. You may ask, is it not a good place to go if you haven't been paid? Well, I've had one opportunity where a tenant complained about a notice that we had given, making that an issue for the tribunal. And at the tribunal, the presiding officers of the tribunal decided to investigate the amount outstanding, to my absolute horror. I don't want the tribunal to determine amounts payable under a lease. It's the choice of my client whether they want to have that done at the tribunal or not. And I walked out of there with an order that the tenant had to pay the money, and it was a significant amount of money. The problem is you now have to convert that order into court process in your local court. And the local court does not recognize that. And if they do, they want the original of this and the original of that. It is trying to forge two different forces, two different recovery players. We call them forums. I just don't think they were made to speak to each other. As I am addressing this to you today, I have to provide comment for one of my clients on major amendments to the Rental Housing Tribunal regulations, and they're planning to become even greater force in the rental market and to involve themselves in even more areas. I get the idea government wishes to push rentals to a specialized tribunal, and I reserve comment on that. I understand that people may want to vent certain disputes in the tribunal. Evictions are unfortunately, as we speak now, completely exempt from the jurisdiction of the tribunal. So the tribunal can say what they want to, but they cannot evict people. And they cannot evict tenants who don't pay. And they're limited. It's residential accommodation, for instance, and there are exceptions even to that. So my advice is try and avoid doing this stuff in mistake number one, so you don't end up involved with mistake number two. These are all distractions that just create problems down the line. If I can see the next slide, please. Yeah, so this is the million-dollar question. I've made some notes there. Hopefully after today, you'll be armed with a better understanding of what you should do. The first thing is you've got to make a decision to act decisively and without emotion. If you are going to write a letter yourself, make sure the right letter is written, that's properly delivered. Let someone sign for it at the property if your domicile provisions are in doubt. If your lease says you've got to send stuff registered post, unfortunately, whether registered post is delivered or not, make sure you send it registered post. Go and deliver a copy there, depending on what your lease says. Make sure you pick the right letter. If you don't do the letter yourself, go to an attorney who understands what he or she is doing. I want you to also understand the issue of termination or cancellation. I touched on that before. If you have a scenario where you terminate and you forget about that letter can come back to bite you. Termination is termination, unless of course the lease carries on a month-to-month basis after that. Termination is a nasty time. If your landlord, for instance, has a small property, let's say nominal rent, doesn't have a bond, he doesn't really have holding costs, and he'll just let the tenant sit there for 6 months before he does something, and you've terminated. You must warn your landlord that he or she could be prejudicing themselves, and that you cannot indefinitely postpone taking action. Obviously, instructing a capable attorney and to make sure that the attorney you dealt with has actually completed evictions, because we have in our industry people who try and do this work, and they'll maybe go to a court file or be crafty and find what they think is an example of this process. But there's a lot more to this process than just being able to do the paperwork. In my time learning evictions and learning rental law, I've had firearm pulled on me at our office. I've had gunshots fired at our office. I've been personally accosted. I've had, you don't know who you're dealing with when you evict people. And for that reason, the additional so-called help is really not required. You need to know how to manage yourself. And the attorney, an aggressive attorney who explains to you that he will do X, Y, and Z to that tenant, and they haven't seen the likes of him or her, could compromise you and your landlord, especially if it becomes an emotional situation and the occupier or the occupier's very big friend needs to vent themselves. There are other things that one can do. We talk about evictions. There's a remedy, for instance, rent interdict, that one can do to attach furniture judicially through the sheriff. If we have a lot of valuables in the property, items that are paid for, let's say a boat or quad bikes or expensive furniture that you saw delivered, but stuff that has real commercial value. It may be worthwhile to do a rent interdict parallel to your eviction, because you can at least secure the rental that is outstanding at that point. And I mean, those are also subcategories. It's stuff that is not really, it's too focused for this conversation, and it would require too much detail. The other thing that I would want to touch on is during our national lockdown from March 2020 to recently, I think it was March or April, when it was finally brought to an end, every set of the regulations, the ones that said you can buy cigarettes or liquor, or you can meet at 50% or 25%, all of them had different stuff, but every single one of them had a provision in regarding evictions, and that evictions were prohibited unless you had ticked one extra box. And there are a lot of boxes we tick when we do an eviction, and that is that you had to try and engage with your tenant in a constructive way, that you had to try and find a solution with the tenant, that you had tried to make an arrangement. It doesn't say what arrangement you should accept. I mean, we have to accept that it has to be a commercially viable arrangement. If, let's say, the tenant has 5 months left on the lease, is 4 months in arrears, and wants to pay it off over a year, surely that can't work. Surely, unless there's a commercial reason to go and extend the lease, why would that work? That's unfortunately or fortunately behind us now. But you know, even with some experience, I learned a very important lesson during the last 2.5 years. I actually found out that if you do engage people and you allow a reasonable time, maybe 2 or 3 weeks for engagement, and try and find a solution, that it can lead to good results. The important thing is that you don't let the conversation be the only action you take. If you have given a reasonable opportunity for the parties to meet each other and to find a resolution for the tenant to either get up to date or vacate, and that hasn't come to fruition, then you have to follow through on your termination notice. Hesitancy is not something that has a place in rental law. And it's something I just want to touch on in the next slide. If you can just turn for me. So quickly, just want to run you through the process, and then in a conclusion, I want to share with you, a bit more detail. So our departure point is that you have to have an illegal occupier. The person in the property is either an illegal occupier or the person is there with rights. So if you have rights, it means that you have a lease that you may be in breach, but that the lease has not been cancelled. So the moment the breach has been done and the time has run out and payment hasn't taken place and you cancel, you have an illegal occupier. Illegal occupiers are also people who are in a property who never had a lease. Illegal occupiers can also include a person who used to be the owner of the property, the bank foreclosed on the property, and they are still occupying. They are treated a little differently in the legislation, but that's another example of how you become an illegal occupier. The other illegal occupier, a good example would be our fluid tenant, where people move in and out of the property and they are, before you know it, you've got a completely different person living there than the one who initially moved in. So the person who can start the eviction is the landlord. Landlord is normally the person who signs the papers, but we also very often have the landlord sign an authority authorizing the rental agent or managing agent to do the application, because normally that individual, the property professional, has the on-the-ground knowledge, and we have a very limited role for the registered owner in a case like that. We have basically 3 steps. The first step is there's an affidavit prepared, either for a magistrate's court eviction or high court eviction. And in that affidavit, you tell a story. You explain to the court how the occupier ended up in the property, if you can explain it. If you were the letting agent or you took over from someone and you inherited this tenant, you explain that. You explain the history of the lease, and you explain how the lease came to its end. So how did you end up with an illegal occupier? We deal with the financial position of the parties. This is a fantastic point to just point out that if you were involved last week and you listened, we spoke about a good application. That a good application is invaluable for us when we prepare this. If you have a situation where you had because you must understand, your tenant is going to put his best foot forward during that application. He's going to show you his best bank statements. He's going to show you all the income in the family and as little expenses as possible. And we use that information when we draft an eviction. We explain to the court, this is what we know. Court doesn't expect us to have a deep insight into the exact financial position of an occupier on the day the papers are signed. We can share what we can, and we have to be honest and frank, but the court doesn't expect me to play private detective. And of course, we have to balance that by showing there is another individual involved in this eviction. It's not all about the tenant's rights. The landlord, your client, has major right. He has the right to own property in terms of our constitution. And we make the point that there are fixed costs, there are holding costs. We show how far the rental has gone into arrears. We show what the bond is, if there's a bond they are paying, rates and taxes, levies. We show maintenance costs, all the costs that are involved in the holding of a property, and we disclose those to a court as well. We then also affirm the fact that we will be complying with the PI Act, and then the set of documents goes to the sheriff. It's served on the local metro. So in Ekurhuleni, we serve it in Germiston at the corporate and legal head office. Served by the sheriff, a certain amount of time goes past. If the matter is not defended, we do the second stage. The second stage is more of a compliance thing. We approach the court directly in a case like that, and we ask for confirmation that we may proceed with the eviction. We detail law clinics and free legal resources that the occupier may need to use to enforce their constitutional rights. We ask a date, and all of this gets served by the sheriff again. And then, I guess some 6-8 weeks later, depending on how full the court roll is, we have a hearing, and that fine day, either myself or another practitioner in my office or an advocate, depending on where we are, gets up in court, and we then explain to the judge or the magistrate the background. We answer questions that may be unclear from the papers. We clarify whether proper notice was given to the occupier if they are present. Sometimes we have a little surprise and we hear nothing from the tenant, and then we have a great parade on the morning of the eviction with some sad stories, etc. I think one special case we had about, must be 3 years ago, I think it was in 2019, one of the coldest weeks in July. We've had some delays with our eviction, and my candidate legal practitioner and I think she joined me that day at court. We actually had the occupier have rent a baby. I don't know if you've heard of this, but it's when you have a child in your family, and by all accounts, since the lease was signed, that child must be 2 years old, but you arrive at the hearing and suddenly that 2-year-old has turned into a 3-month-old because it generates sympathy, or attempts to generate sympathy. So we have all sorts of things that happen on that day. We try and persuade the court that the occupiers had a lot of time to make alternative arrangements, or get alternative accommodation. And we then normally ask the court to evict them within 7 days. And depending on whether the presiding officer, whether the magistrate or judge, what their feelings are, the prevailing media sentiment, we normally get anywhere between 15 and 45 days for the occupier to vacate. That's really, we can argue it, but we get what we get. And sometimes you get a judge or magistrate that simply says 30 days, and that's what will happen. So the order then, sometimes we have to have the order served on the tenant by the sheriff, and so there's almost like a warning. The order is served to say, listen, this is the order that was given. You have to vacate within X amount of time, and if you don't vacate, then the sheriff will pop in and will then evict you and anyone on this property. The sheriff does that. Well, it's good practice so that the individual in question has the opportunity to leave. There are some practical issues around the sheriff evicting people. The sheriff does not keep a crew of people on hand always for this, and sometimes they have to bring in contractors or additional labor resources to help move but it happens under the auspices, under the direct control of a sheriff. If you have a really nasty one, the sheriff will appoint the Red Ants, who are probably the best known team to do evictions, and then the sheriff will stand and supervise. And it is literally so. If you have gone through this process as a tenant and you haven't listened and you haven't abided by the order, then the sheriff will put you outside on the street. So if we could go to the next slide. So I wanted to share that photo with you. Jan, thanks for being a good sport. That is not a photo that Jan found. That is an eviction photo that was taken where we did an eviction in an upmarket estate. Right at the back there's a human being standing behind all the stuff. That's the sheriff still packing stuff outside, getting ready to move it out onto the pavement. This was a particularly rough eviction. It was opposed, there was an appeal. And the reason I wanted you to see that is to understand that when a client consults me to ask, what's it going to cost? How long is it going to take? And how should I, sometimes people ask me, how should I be thinking about this? And I can maybe just start there and say this. I can't forecast how long an eviction will take. No attorney can do that. We can't forecast if the occupier will leave, because a lot of people have a lot of bravado, but when the process starts, they whimper and they disappear overnight. And that's a great win for our landlords. This is really challenging work and sometimes dangerous work. And you have to have a passion for property. Jan, who's hosting me today, he shares my passion for property. We both have conveyancing practices. We both love property. And the reality of this is, as ugly as that photo is, if we don't protect landlords' rights, people won't want to buy property and own property anymore. If it is possible to stay in a property indefinitely, there is no purpose to property ownership. So you've got to ask yourself, when you have trouble, when you've looked at those danger signs we discussed, you want to ask yourself, what is my rental? What is my landlord losing a day? And it's a very simple calculation. You look at your rent, you take your rates and taxes. If there are levies, you take that. And if there are additional costs on the lease that needs to be recovered out of the tenant, you take all of that and you divide it by 30 just to be on the safe side. And you work out what your daily cost is a day. Every day that you wonder about what you're going to do next or what your landlord's going to do next, that is the loss that's going to be suffered. And what we often find is a person arrives at my door, rent hasn't been paid for 5 months. They've tried all sorts of things. They've written letters, they've spoken, they've tried to nurse the tenant, and nothing has happened. And they may be 80, 90,000. I've had people arrive here where the rent's 300,000 Rand in arrears. And then I tell them, well, we first have to do the 20 business day letter, which means another month, and they have a fit. And you say to them, if you think that is rough, wait till you see. I can't predict. One thing I can predict that I will get you an eviction order, and I will evict your tenant because I have a record that I'm proud of. It's a sense of pride for us to see these things through. But we put rules to doing the work. The stuff we mentioned, where you don't go and get bouncers and stuff involved, because it becomes incredibly, incredibly dangerous for us. And so the point I want to make is this. When you talk about the cost of an eviction, it could be the same cost that you pay for any legal matter. You must think that this is a court application. If you had to go to court, most times you're going to spend between 10,000 Rand and 100,000 Rand. And evictions are no different. The challenge is, I can't tell you how fast your tenant leaves. I've had people, best known one, I had an individual who I later found out was an awaiting trial murderer the person had her own family murdered. And I did this during my background before we started the eviction. And I said to my landlord, I have to write the breach notice and then the termination notice, and then I've got to start the eviction. And I said to him, this individual is not scared of the court. We are going to be here for a long, long time. And lo and behold, when I delivered the breach notice, I got an email from her saying, sorry, we are late with the rent. We'll deliver the keys on the 31st. And they did, and they left. And then I've had the granny who holds on for dear life, and you fight for 8 or 10 months. You just can't predict these things. The things that you can manage are to take action when you have a problem. You've got to work out what's the cost of waiting per day. And then, of course, you've got to work out what is the cost of losing the actual asset. Because what are you going to do if you do nothing? You've got to. It's unfortunately, it is one of those things. If your tenant doesn't pay and you want to have, if you may encounter difficulties, you've got to take decisive action. You've just got to do it, as Nike would say. I wanted to just mention in closing, before we do questions, that we developed an integrated credit control solution for clients, where the client, where if you manage a large portfolio of properties, where we can plug into your portfolio. I can have a sit down if anyone is interested, and I can show you how you can access breach notices and termination notices and the like cost effectively and predictably, so that you can always make sure that your letters are the right letters, that you don't end up writing letters that are nonsense, or that you do stuff that has to be repeated. It's just one of the solutions we offer. I really, really appreciate your time, appreciate the fact that everyone has listened in, and that so many of you joined today. Jan, if you have questions lined up, I'm more than happy to listen and hear what we have going.
Thank you, Heinrich. That was exceptionally interesting. Thank you. Really appreciate it. Not a lot of questions. I've got a question here from Annie. She says, I currently have a gent renting from me directly who I do not have a lease with, I suppose a lease agreement. Can I now present him with a lease agreement? Heinrich?
Yes, that's actually a very interesting one. It's quite obscure, but there's a provision in the Rental Housing Act that says if you, and part of this will go back to our studies where we say an agreement can be formed through the conduct of the parties, but it's actually determined by statute. There's a provision in the Rental Housing Act or resolutions or regulations where if you present a person in the property with a lease that is signed by you, you obviously keep a copy, and you behave in accordance with the lease. In other words, you bill in accordance with the lease, you maintain in terms of the lease, a court will see that to be that written lease, even though signed by one party, as the signed lease. Very dangerous, because you don't have the domicile provisions and other things that protect you, but that is one way to do it.
Okay. Then from, I can't see the name, Heinrich, credit checks don't give you comprehensive credit ratings. Where can you list and in turn find professional tenants to avoid?
Let me just review that question again.
This credit checks
so credit listings don't.
Carry on.
No. Let's just read it back to me again, Jan.
Credit checks don't give you comprehensive credit ratings. Where can you list and in turn find professional tenants to avoid? In other words, if somebody is a professional tenant, as you referred to, is there a list that we can check to see if that person has got evictions against his name?
There isn't. The best tenant-focused credit bureau in the country is TPN. It was started many years ago by a very, very enterprising individual called Michelle Dickens, and she started a tenant-specific credit bureau. It's a lot of people record tenant behavior there. I think it is a great way for people to see So how it would work is people would integrate their payment data every month, and you as a tenant can build up a good payment profile. So it's not a case of only your bank statements or your pay slips. You can actually show, and it can be authenticated by a third party, that you have a regular habit of paying your rent on time. So that is, I guess, that is one place to go.
Okay. Thanks, Heinrich. A question from Edwin. I have a tenant which showed all the signs, 3 months behind on lease, and I've given him 30-day notice. He has a month-old baby. Does he have any rights?
Tenant is 3 months behind.
Yeah, but the point is that he's got a 1-month-old baby.
Yes. So yeah, we do disclose to the court if there are children in a property and their ages. We do disclose the fact that a property, household, or a household may be headed up by a woman. Those are specific things if people are handicapped. But I can tell you that I have had the, I don't want to say misfortune, but I have had in my career handicapped people, person on oxygen, wasn't on oxygen when the lease was signed. I had a tenant have a heart attack on the day of the eviction, or faked a heart attack. These things happen in life. The court takes those things into consideration when it determines how much time the tenant should be given to vacate the property.
Okay. Heinrich, then Chris sent me a message privately to me, maybe more a statement than a question. He says, for what it is worth, in our application, we require current and previous rental details and put much stock on the previous rental reference. Sorry, we also do this for the place of employment for all parties that will be included in the lease. Then we never indicate that our reference is for rental, only as a credit application. I think you covered that last week, is that you must get as much information that you can on the potential tenant. Any questions anymore? But I see Rina made a statement that you can get she calls it a legal product covering up to 260,000 rand per case, and you can use their attorneys to assist you. Are you aware of something like that?
There are lots of products in the market. Some are so-called subscription products. Most and I have looked at some. There's also eviction insurance. It's something that I've actually looked at as a model. If one had enough traction, maybe if the participants would like to indicate, maybe they drop you an email afterwards if they would want to participate in something like that. You do need scale to make something like that work. Yes, you can get legal insurance. It's a great way to deal with stuff, and yes, they do attend to that. Just remember that it is no different in a situation like, let's say, the legal insurance appoints an attorney. Your loss is not only the eviction. So I can almost equate it to the situation where you have insurance over your property and your geyser bursts, and you don't get the contractor that fixes the geyser. So as long as they are seen to be getting along with matters, then they are doing their job. But it may end up that you obviously have no direct relationship with that individual. Indeed, and if they take 2 years with an eviction and you end up losing 600,000 rands worth of rent and your property in the process, but you get your eviction, then they have fulfilled the terms of the policy. So just be careful, careful with that. Yeah. Evictions are serious things. You don't want to be a number.
Yeah. Heinrich, thank you so much. You based in Edenvale. but surely you can do work here in Benoni as well.
Yes, I've done evictions in Stellenbosch, PE, Pretoria, even north of Pretoria. I'm limited by my license to practice in South Africa.
Yeah, well done, Heinrich. Heinrich. I've known Heinrich for many years. He's a solid, straightforward, honest attorney, and having done more than 500 evictions, I'm sure he knows exactly what he's doing. So just a moment, sorry about that. So please make use of him. On your screen you can see it's Bennett McNaughton Attorneys, Heinrich's name and his email address and telephone number. Don't hesitate to contact Heinrich. I see just before we go, there's a message here from Richard. Hi Jan, can we use social media to warn fellow agents regarding defaulters? Heinrich, maybe as a last question.
Could have consequences, defamation claims. You also want to look at your PAPIA stuff. Are you not pushing the limits of why you have someone's data if you use social media to discredit them? You've got to look at your tenant application and see how far you can publish payment patterns and profiles. If you were in the Netherlands, it would be great because you would have a person in an orange suit sitting outside your house and follow you to work and back and wherever you go and embarrass you into paying. But so this is South Africa, social media, and you may have a gun pointed at you. Be careful. Oh, the squatter rights. Sorry, Jan, do you mind if I quickly just answer that? Sorry, Jan, you've gone on mute.
Sorry, Heinrich, did you see the question from Andy? When do you have
squatter rights?
Squatter rights, yeah.
Yikes, this is, I don't want to take much more time. Can I just maybe explain where this concept of squatter rights comes from? Sorry, this is maybe something we could have discussed earlier, but it may address this for you. So many years ago, with the advent of the new South Africa and new democracy, our government set to work to protect vulnerable people, to protect people whose constitutional rights could be affected. One of those pieces of legislation that evolved was the so-called PI Act. PI was originally written to manage land invasions, let's just call it that, and let's say urban land invasions and land occupations. And the idea was that you would have a standard procedure. If people occupied a piece of property and you needed to evict them, then there would be a process, and there would be the court would listen to the rights and balance the rights of everyone, etc. So, and I must blame one of our colleagues for this. Some bright attorney said, but if a person who is a squatter, for want of a better word, has the right to full due process and all the mollycoddling that this act brings about, then the rich guy sitting in his ivory tower, renting at the top of the Michelangelo Towers in Sandton must have the same rights, because the Constitution guarantees us equality before the law. And they, unfortunately, as a result of the way our precedent system works, PI became applicable to every residential and urban eviction in South Africa. So a person who stands to be evicted claims so-called squatter rights. You have squatter rights if you refuse to leave without a court order. And as we demonstrated earlier on, those squatter rights will last for as long as the eviction process takes, or your nerves hold out. So potentially every one of the 50 odd participants today have squatter rights if you go rent and you fail to pay rent. Are they like an invisibility cloak or a Marvel a weapon or a shield, well, only for a little while, because you will end up leaving. Yeah.
Heinrich, then the last one I see, if you have a bad paying tenant and they are finally leaving, then you get an agent phoning you for a reference on them. How do you handle this, as you don't want to get stuck with this person?
I think in a situation like that, I do not have the appropriate level of POPIA consent to be sharing payment information. Yeah, and I must tell you, just in our management company, if someone approaches us for a reference, obviously that's a sign the tenant is leaving. We always ask the tenant for consent, specific consent, to share their payment history. And I think in a case like that, the tenant would probably decline the consent. I will leave it up to them to market themselves. Yeah, I wouldn't sell them as a great opportunity to another agent or landlord. It hurts the industry.
Okay. Thank you everybody. I've had a few people saying thank you, they really enjoyed it and so forth. Very informative. Thanks, Johan. Amazing. Thank you, Heinrich, once again. So there's Pietro quickly. We do reference checks on the last 2-3 landlords to avoid the issue of the current landlord, to just get rid of them. Okay, so that's just basically answering something. Thank you, people. You can leave the meeting, and then a few of us will stay behind just to wrap it up quickly. Thank you, everybody. Have a good week.